Let's start. Good morning, everyone. My name is Tahmina Karimova. Today, I will be moderating this session. Today, we have a great privilege and honor to have our session on the research seminar related to the topic of addressing sexual harassment as a work-related risk, issues and dilemmas. Before I present the speaker, I would like to give you a very small overview of the event. Research department seminar series are events that are organized by the research department that are aimed at bridging or making a dialogue between the external experts, academics, practitioners, and the ILO staff on issues of interest to the mandate of the ILO. These seminar series present a very good opportunity to discuss and to have an exchange. And as I said, today we have an honor to welcome Professor Rachel Cox. Professor Rachel Cox is a professor of law at the Faculty of Political Science and Law of the Université du Québec à Montréal. She's a member of the Quebec Bar. She works a lot within the Partnership Research Action, and she has been the chair of the Quebec Committee inquiring into law reform on sexual harassment at work. Professor Cox is a renowned scholar. She works on many topical issues in the area of labor law. She has written extensively on domestic violence, workplace violence, and harassment. She has made a great contribution to the knowledge and the legal analysis of this issue and many other issues of interest to the work of the ILO worldwide. As you may have already known her, she has actually no need to be presented. But I just wanted to say that her analysis always includes an approach that contributes to a comprehensive understanding of the issues and different aspects of social legal research. Her works are always a model of legal analysis, both at the methodological and theoretical level. So before I pass the floor to Professor Cox, I just wanted to remind you how the session will be organized. It is a hybrid event, so we will have our colleagues both online and present here in the room. The session is recorded. The questions and the dialogue between the staff and our guest speaker will start after the presentation, which will be around 30-35 minutes. You are also welcome to send your questions directly online. And with further ado, I would like to pass the floor to Professor Cox. Thank you so much for coming.
Thank you, Tamina, for that glowing introduction. Thank you for the invitation to Jane and you today. Thank you very much, Tamina, for that glowing introduction. And thank you, everyone, for coming to this conference today. I look forward to exchanging with you. Without further ado, I'm going to share my screen. That works. So today's talk is about addressing sexual harassment as a work-related risk. One second while I go forward. Let's work. Just a note, today I'll be using the expression work, health, and safety rather than OSH, as most people like to say, or occupational safety and health. And I do that deliberately as a feminist engaged in prevention at work. Risks for women often arise because of things other than job duties per se. They arise at the margin of work, for example, waiting for a lift home after a night shift, at the Christmas party where alcohol is served, doing night work, traveling to and from work. And therefore, it's important to move from a strictly biomedical model to a biopsychosocial model of looking at health and safety in order to include risks that are based on identity rather than a chemical risk or a physical risk, et cetera. So I say WHS, and I decided not to change that today. Today, my plan is to very briefly explain what I'm talking about by the expression sexual harassment, to touch on what we've learned so far in order to really contextualize what we're looking for as we turn to work health and safety framework in order to try to eradicate sexual harassment at work. Then, once the promise of this framework has been established, I'd like to look at how best should we mobilize it in various contexts in order to fight sexual harassment at work. If I have time, I'll give one example from Quebec about how principles and can need to be applied in a very context-specific way. And I'll try to identify some areas for future research because it is really a very new area in terms of how to mobilize a WHS framework for sexual harassment. So what are we talking about? A pervasive and persistent problem for women at work, and one that has united women worldwide. For me, sexual harassment is a form of gender-based violence, but one that is distinct from domestic or family violence. In North America, there's been a shift between talking about sexual harassment, then talking about sex harassment, and now we have a tendency to say sex-based harassment. And this is in recognition of the fact that sexual harassment is about domination of women, policing masculinity, rather than sexual desire or sexual conquest. However, as a lawyer, which is my training, I use the word sexual harassment. Why? Because that is a recognized concept in law, as opposed to gender-based violence, which doesn't appear in our legislation. So for us, we get traction by talking about sexual harassment. This said, sexual harassment has been broadened to the extent that today in Quebec law and as well as in Canadian law, it includes non-sexualized practices. So gender harassment or sexist harassment or hostile work environment harassment. It also includes sexual assault. And in certain jurisdictions, for example, in Ontario, the health and safety legislation uses sexual harassment as a term that also covers harassment based on sexual orientation and gender identity or expression. Sexual harassment causes corrosive harm for targets, for well-being, health, safety, for their professional trajectory. Often women will have to quit their job or are fired because of sexual harassment. And as I said in my opening remarks, at the same time, it's an issue that really has united women across the world and become a global campaign. This is embodied in the campaign for Convention C-190 and also in the Me Too movements more generally, where a Me Too movement became Me Too movements across the world, playing out in different ways, but with a common goal of women speaking up about sexual harassment. What are we up against? Why is it so pervasive? Why is it so persistent? It's because sexual harassment is really linked to discrimination and inequality in society at large. And a recent ILO study remarked on the significant linkage between people's vulnerability to discrimination in life in general and the likelihood that they face violence and harassment at work. So fueled by a general climate of injustice and inequality, no wonder it's a hard thing to fight. We also have to take into account the fact that sexual harassment is fundamentally about power. Sexual harassment at work is particularly corrosive because women are captive economically when they are at work. And as Canada's Supreme Court once characterized sexual harassment as both an economic and a sexual abuse of power. So a particularly key place for women to fight sexual harassment, the world of work. At the same time, sexual harassment really is a technology of sexism. In a recent Canadian study, the highest prevalence for sexual harassment was found both in the most male-dominated professions and in the most female-dominated professions, expressing itself in different ways. In the male-dominated professions, women were targeted by colleagues, and in the female-dominated professions, women were targeted by their clients, their patients, their students, etc. So we really see how sexual harassment operates to keep the sex segregation in the labor market going. And we see also how we have to understand sexual harassment on a continuum of violence, where women are excluded from the male-dominated jobs and exploited in the female-dominated jobs. This said, what have we learned so far about legal frameworks for sexual harassment? I warn you, it's a little grim. Legal prohibitions and complaints-based reactive regimes have simply not been effective at eliminating sexual harassment at work. We can look at studies, we can look at the Me Too movements. As one scholar said, reliance on reporting systems to root out those who harass amounts to hunting for bad apples one at a time. In fact, we should be looking for bad barrels, not bad apples. What about then employer policies on sexual harassment? Let's go to the workplace instead of a legislative framework. We have also learned through a vast body of literature that by themselves, employer policies on sexual harassment are not effective in preventing sexual harassment at work either. In fact, because women know that they can't trust these policies and risk being ostracized and silenced again, victimized again when they report, policies have in fact served to protect employers from accusations, from responsibility for sexual harassment, rather than the workers themselves. Why? Because often the employer will be able to say, well, I had a policy on sexual harassment. Why didn't you use it? What about training? Conventional approaches to sexual harassment training don't reduce sexually harassing behavior. Another grim observation, and therefore have been referred to as a misguided culture of compliance, but superficial compliance rather than an engagement with fundamental change, with fundamental transformation in the workplace. And again, ironically, conventional approaches to sexual harassment training can even make things worse for women, for example, in male-dominated environments when they become targets for even more jokes and there's even more backlash against them. So to sum up, the 3 Ps, policies, procedures, and prohibitions have not worked. They have been, with some exceptions, largely performative. And we have been able, in fact, to document a really huge disjuncture between the terms of the law and between women's experience of sexual harassment at work. We see that simply naming sexual harassment has not in and of itself brought about real change. And in this context, a lot of gender equality scholars, lawyers engaged in anti-discrimination and human rights law have gradually and fairly universally come around to the fact that we need legislative frameworks that are going to push for prevention of sexual harassment. And it's in this context that we turn to the work health and safety regime to see if we couldn't do better in terms of preventing sexual harassment. A wide range of studies have come to the conclusion that we have to talk about prevention rather than complaints-based mechanisms. Some Norwegian, some Nordic scholars are now saying, well, why do women have to clean up the mess? Like, why do we have to ask the victim to come forth, report, to manage, to deal with the sexual harassment? We need systems. We need everybody else to be doing that. And an advantage of prevention is also the fact that it calls attention to the fact that sexual harassment is not inevitable, that it's preventable, that it's related to organizational risks, primarily. Talking about prevention means that harassment becomes visible, becomes speakable, and we situate it in a system of rules and ways of doing things. The equivalent for social science studies would be, for example, talking about the need to look at organizational drivers for sexual harassment rather than personal, individual risk factors. Again, it is an important moment to say we have to stop thinking about sexual harassment as something that goes on between 2 people. Another way of saying that is we have to reimagine it, as the Nordic scholars have recently done in a book entitled Reimagining Sexual Harassment. We have to stop constructing it as a drama with 2 characters, the perpetrator and the victim, and a third actor, maybe the bystander, and maybe some legal person in the background. That's a much too limited way of looking at things. We have to step back and rely on the social sciences to let us imagine sexual harassment in its context as something embedded in a series of rules. And this is important when we come to say, how are we going to prevent it? What do we need to look at? So what does a work health and safety framework have to offer? I think it's important to start off now because we're looking at a lot of gender scholars who are promoting prevention of sexual harassment at work, to take a step back and look at what work health and safety regimes have traditionally done. So work health and safety, or OSH, occupational safety and health, has in the past largely been based on this biomedical model of health. OSH has tried to isolate, to reduce study of safety and health to single proximate factors that cause injury or illness. And this has been very useful for something like asbestosis, for example. However, we've gradually come to the recognition that this biomedical model really has to be expanded to a biopsychosocial model, which is then going to take into account identity-based risk factors. So we're not starting on a blank page in terms of work health and safety. We're starting on a page where women and risks for women workers and risks coming from women's work, and there is a fine distinction there, have had to fight for a place within work health and safety regimes. Anybody who's worked on the ground, usually if you have a work health and safety meeting in traditional environments, you're going to be sitting around the table with a lot of men. And if you do the women's committees, well, then that's going to be mostly women or all women. So we just have to take into account that the institutions that are responsible for work health and safety have also been shaped by this historical model. Now, things really are changing. We're moving from looking at just safety to looking at health, looking at psychological health as well as physical health, but we are in a stage of transition. And it's in this transitional stage that prevention of sexual harassment is going to arrive. Now, what is the promise of the work health and safety framework? It is a unique regime within labor and social law because employers have a positive duty to ensure health and safety. We generally have a general duty clause and an obligation of due diligence for employers. These broad duties are then filled out with regulations, codes of practice, guidance, which are much more fluid and elements that are easier to change within the regime, but all backed up by a very flexible general duty clause. And work health and safety law has also kind of been a precursor. Why? Because lately, work health and safety regimes have really expanded in the sense of C-190 to cover not employees, but rather the world of work. In certain countries, for example, Australia, all kinds of work, including independent work, are covered. In Quebec, volunteer work or work-based training, people doing work-based training are also covered by our work health and safety regime. All kinds of risks are covered, all kinds of work arrangements. And therefore, it's a very promising field in that sense to work on eradication of sexual harassment, including on the margins of work and informal work, et cetera. Another potential that work health and safety gives us when we're looking to prevent sexual harassment is the concept of proactive risk management. So work health and safety regimes are characterized by systematic approaches that involve, on an ongoing basis, identifying risks, assessing them, and then seeing, well, how can we better eliminate or control them? And this happens all with worker participation, where we're going to the people who are doing the work, who know best, who have particular expertise that no one else does, to say, well, what are the real risks involved in the work that you do? And also, what should we do to mitigate those risks if they can't be eliminated? So instead of individuals' sexual harassment when it has occurred, we're looking at systems and cultures, and the duties are ongoing. Another interesting part of the work health and safety framework is the possibility for voice and certain levers which give workers more agency. Workers are supposed to participate in these regimes. Several countries have health and safety committees, prevention representatives that have broad powers. We're also there's also the obligation for the employer to inform and train people on the risks associated with their jobs, the right to refuse dangerous work. And in stark contrast to the human rights regime, work health and safety involves having a regulatory agency that sparks prevention in workplaces. So it's a very decentered model, but with external oversight by the agency, which will provide assistance, build the capacity of employers to comply, give them tools, and also proactively enforce the law, not through individual recourse, but rather through inspection, through correction notices if necessary, and ultimately fines, and in some countries, imprisonment. So a really proactive way of implementing worker rights. How best to mobilize this framework now? C-190 says that, for example, definitions can be in separate concepts or all together. And then we have to say, well, should we be using separate concepts? Should we be addressing sexual harassment, gender-based violence, or simply violence and harassment in the workplace? Catherine Lapel remarked that gender neutrality is an impediment to the development of adequate regulatory protections. So that's something to keep in mind when we look at various regimes. In the States, one tendency that is emerging is the idea that we should have general respect promotion programs, which are gender neutral by design. And the reasons that are put forth for this strategy is because the feeling is that we can attract broader audiences. We're going to have a policy that's relevant to everyone, not just women, and we're going to avoid that backlash or resistance that would be met by interventions that exclusively target sexual harassment and seem to be concentrated on women. There's the thinking. There's also some research that says, well, if we promote general organizational justice and fairness, that's going to help too, that even in a climate which is likely to have sexual harassment, if things are generally managed in a fair way, there will be less occurrence of sexual harassment. This is one approach, so gender neutral by design. The other tendency that we see is in this shift where health and safety now is going to include worker as psychological health and well-being, is the management of psychosocial risks. But psychosocial risks represent really a diverse array of phenomena, often linked to global changes in work organization. And they're going to include things like too much work, understaffing, job insecurity, role ambiguity, effort reward imbalance, etc. So this can be a very contested ground because, as labor people would know, we are inching closer to management rights and the way that management rights might be limited by health and safety law. If you look at the place of sexual harassment within general psychosocial risk management, it ends up being the drawer and the drawer and the drawer and the drawer. So really it will be reduced to harmful behaviors, and then we see include sexual harassment. So at least on paper, it's largely gender neutral. So another gender neutral approach. The question then is, are we making sexual harassment invisible again? Sexual harassment is a relatively new concept, a term coined in the 1970s, and in the States by scholars such as Catherine McKinnon, saying, well, we need to give it a name. And what we've seen in a variety of different countries is when we start to risk manage sexual harassment within a general framework for psychological harassment, the case in Quebec, or bullying, the case in Australia, or psychosocial risk management, we end up finding that it disappears. Would this be the same thing for a general risk management framework for violence and harassment? And if so, what are the consequences? So the term sexual harassment has really been significantly linked to legal prohibitions. We see really a very close connection between the developments in the legal framework and political activism, feminist activism around combating sexual harassment. At the same time, this is an ambiguous, there's an ambiguity here, because women really hesitate to call their experience sexual harassment. If you ask women, have you been sexually harassed? It's not going to be a me too, it's going to be a not me. At the same time, if you ask women, have you experienced a specific behavior that is part of sexual harassment, then you're going to get rates around, 70, 80, 90% of women who say, yes, I have had to avoid a colleague because I felt sexual pressure from him, or yes, I stopped going to the parties because I felt so uncomfortable. So we see that there is what has been called denotative hesitancy. And at the same time, women don't want to say, oh, that is sexual harassment, that is illegal behavior. So a certain hesitancy there. That brings me to the question, what to do? Should we avoid resistance by not talking about sexual harassment? Or rather, is naming sexual harassment as such not also a form of prevention, a form of making sexual harassment visible and speakable? So Catherine McKinnon brought up these issues while she was campaigning with others for sexual harassment to become illegal. And there's also a recent study with an experimental forum using a naming, blaming, and claiming framework that concluded that naming sexual harassment really is a prerequisite to addressing it in the workplace. Harassers were less willing to engage in harassing behavior. Targets were more likely to say, oh, yes, that is sexual harassment. And third parties were more likely to intervene once there'd been explanation, familiarization, discussion, dialogue around sexual harassment. There are associated issues here too. How do we collect data about sexual harassment if it doesn't have a name anymore, if it's disappears in larger concepts? So again, looking at risk factors to see, do we need specific prevention for sexual harassment? It's true that there are personal, individual factors that will make sexual harassment more likely to occur. For perpetrators, that's being sexist. For targets, number one, just being a woman, being a young woman gets worse, being lesbian, gay, trans, etc., living with a handicap as well, or being a single mother. And that goes back to the being economically captive. Again, sexual harassment is about power. However, again, scholarship is bringing us to the fact that it really is organizational factors rather than individual characteristics that are going to determine whether sexual harassment occurs. In other words, they are reading the messages. And the harassers won't harass when they know it's acceptable, and they do harass because it's tolerated. So I looked at risk factors for sexual harassment and compared them to risk factors for violence and harassment in general. Risk factors for sexual harassment include men being dominant, be it in terms of numbers, be it in terms of image, of structures, masculinity contest cultures where masculine ideals are taken to the extreme. For example, in construction, in police work, in the armed forces are also climates that are propitious for sexual harassment, as well as strict hierarchical structures, which is why you get a lot of sexual harassment, for example, in the legal profession or in the medical profession. On the other hand, climate of tolerance for sexual harassment is also a risk factor, as is generally uncivil or unjust climates. And interestingly, the presence of other psychosocial risks has also been identified as a risk factor for sexual harassment. So you can see we're kind of creeping towards more general factors here. In terms of work arrangements, doing precarious work has been associated with an increased risk of sexual harassment by several different studies. And that's why in sectors, be it culture or construction, where there's a lot of turnover and people are constantly going from one contract to the next, there's also a lot of sexual harassment. But at the same time, insecure employment has been found to be linked to violence in general. We need to unpack that about what does insecure employment mean to better understand whether these risk factors are the same or not. In terms of working conditions, isolated or remote work, including restrictive spaces like being stuck in a car with somebody or working from home, alcohol, working with the clients or the public, these are all risk factors for sexual harassment. But at the same time, at least in theory, at least in the literature, for violence in general, the question remains, how exactly do these factors play out in shaping the risk of sexual harassment in specific sectors? And when we look at more closely, I've certainly come to the conclusion that there's not a lot of literature. There really isn't a lot of empirical evidence published yet on how to do risk assessments for sexual harassment. And part of the reason for that is that it is we have this challenge of going from general principles to on the ground risk assessments, because risk assessment has to be by nature sector specific. And in tune to the local situation. So for example, Gonzalez and colleagues just came up with a co-constructed survey tool. And at the same time, we have other interesting models, for example, of the European Transport Workers Federation, who came up with a very interesting framework for preventing violence and harassment at work, but with a solid section on gender responsive risk assessment, talking about specific risks for women in the transport sector. For example, what does it mean to work a night? What does it mean to work alone? Finding that women were more sexually harassed, and particularly if they were from diverse ethnic or racial backgrounds. Australia has promising practices. They have specific tools on sexual harassment, but they also refer to other guides in terms of workplace aggression and violence in general, workplace bullying, and also psychosocial risks, and also family and domestic violence. So here we have really a complete, I would say, but also very lengthy guidance tool. Turning to Quebec as an example now of how these considerations play out in terms of preventing psychological harassment. In Quebec, sexual harassment in the last 2 decades has largely been seen as a work standard. Psychological harassment was included in the Labor Standards Act in 2002, and in 2018, again, in the wake of the Me Too movements, specific provisions were added to say that sexual harassment is part of psychological harassment. And also we added in 2018 an obligation for employers to adopt a policy to prevent harassment, including sexual harassment, and complaints mechanisms. Now that sounds great, but what that translated into, in fact, in a labor standards context, is really a policy that contains no primary prevention. It really is, so it's called prevention and complaints procedures. It really is complaints procedures. And all the enforcement that comes with that in a labor standards context is, does the employer have a policy? Has it been posted? And does it mention, and that can even be, and this policy applies to sexual harassment and nothing else. Does it mention sexual harassment? All employers need to do to comply, and there's, pretty good compliance, because it's really easy. You download the model, put somebody's name, put it up on the bulletin board or send it in an email, and that's it. Disturbingly, in this model policy, there is no mention of the employer's obligations in terms of the work health and safety regime. Since 2021, there is a mention of an explicit obligation for the employer within the general duty clause to protect the health and safety of workers and protect them faced with violence, including violence including domestic violence, family violence, or sexual violence in the workplace. However, in contrast to the domestic violence provisions, which were the fruit of a large campaign brought by women's groups with unions in Quebec for domestic violence to be covered by the Work Health and Safety Act, there's been really very little implementation for this newly explicited, because it was always there in the general duty, obligation to prevent sexual violence. There's no specific guidance. And the only question that the inspectorate will ask is, does the employer have a policy? And the work standards policy is considered to be good enough. So very little specific implementation. My committee did empirical research, and I don't think that anybody we talked to at the inspectorate mentioned a organizational risk factor for sexual harassment. Indeed, we even found that in many cases, the inspectorate would simply, if they went to a workplace because there'd been a complaint of sexual harassment, if the sexually harassed woman had left, they would put an end to the intervention. So when you unpack that, you see that with that vision, the risk is the woman. She leaves, there's no more risk. And we just have to take a moment. I see people laughing, but that's really it. The risk is not the woman. The risk is the harasser who's remained in the workplace after excluding the woman. So we're talking here about a major paradigm shift in terms of recognizing sexual harassment as a legitimate work-related risk. What did the committee recommend? In terms of changing that paradigm, we've recommended that there be an explicit right to refuse dangerous work if in a case of sexual harassment. And we've also recommended a specific regulation on preventing sexual violence. Why? To enable the inspectorate who's willing but needs tools, needs instruction, and to clarify expectations for employers, and also so that we can ask for specific targeted training on sexual harassment. Now, you may ask, why not as a psychosocial risk? Because there are also new provisions on psychosocial risks. And this comes down to an issue which I think is a universal one. As feminists, as preventionists, we chose not to recommend inclusion of sexual harassment as a psychosocial risk. Why? Because right now our employers and our unions are negotiating psychosocial risks. It is a hotly contested issue. The release time in order to work on psychosocial risk assessment and management is also hotly contested. To the extent that we want something to really happen on sexual harassment, we chose not to bundle that with psychosocial risks to make sure that preventing sexual harassment contributed to generally preventing violence and harassment instead of competing with other themes. Areas for future research then. My questions are, to prevent sexual harassment, is it necessary or even preferable to name it as such? I mean, I think you can see, I tend to think yes, but I think it's important to ask ourselves that question. And then in terms of naming it, well, do we combine risk management with a risk management framework for violence and harassment or psychosocial risks? And as you can see with the Quebec example, I think that the answer to that question is really context specific. At the same time, the term sexual harassment has often been associated with a model where we're talking about harassing white middle-class women at work and not necessarily taking into account women in all their diversity and the specific experience of sexual harassment, racist harassment, et cetera, that these women are faced with. In a context of increased fishing of the workplace, it's easy enough to say, well, we'll do away with insecure working arrangements in order to combat sexual harassment. But personally, I'm not holding my breath on that one. So the questions are raised then when these factors are so systemic, how do we mitigate them? How do we address those kinds of risks? So in theory, if a risk can't be mitigated, employers have an increased and intensified obligation of due diligence in terms of foresight, effectiveness, and control. How do we, in the case of sexual harassment, hold employers to that obligation in a context of insecure work? Another issue, third-party sexual harassment. So as I was saying, I think it's important. We saw that sexual harassment is associated with exploitation of women in female-dominated sectors. We've seen, and it's often discounted as something that is not harmful when it actually really can be. Post-COVID, if we can talk about post-COVID, or let's just say in the wake of the pandemic, ongoing, and also in the context of staffing shortages, there's been a lot more third-party violence, including sexual violence towards workers. A report, which is not just recent, it's actually not even published yet, still in press, by Jane Pellinger, has come to the conclusion that we still need dedicated guidelines on third-party harassment. And within those guidelines to improve the gender responsiveness of the risk assessment. So that's another future area. And I would also say it's a really good place to come down on in terms of unifying workers in terms of starting the discussion about prevention of sexual harassment, in terms of getting those traditional health and safety people and structures to start talking, first of all, within their own membership to women and others, workers in other situations of vulnerability to sexual harassment. Then there's this issue of competing with or contributing to, as I was saying, in a context of scarce resources, where in many situations, unions have less bargaining power than they used to. How can we use prevention of sexual harassment to create new solidarities, to renew the union movement, to renew the work health and safety movement? We have some really interesting examples. C190, as Jane Pillinger and colleagues have pointed out, was a woman-led movement, but that actually made gains for all workers in terms of violence and harassment in the world of work. And I would say in Quebec, we had a similar experience where a campaign to include domestic violence within the work health and safety regime, which was led by women's groups, joined massively by unions, leading to a legislative change and some meaningful implementation, also was the spark that led to adoption of a specific provision on violence and harassment in general, including psychological violence. So it was a gain for everybody. As I said before, these kinds of issues are not traditional work health and safety issues. And as such, that creates both a challenge, but an opportunity for renewal. One of those issues, when we're talking about using traditional work health and safety mechanisms, structures to prevent sexual harassment, there is at times an issue a little bit reminiscent of the debates on gender mainstreaming, where we say, well, how are these traditional structures going to carry forward the feminist project, the feminist objectives that we're looking at? And there's been some interesting work on models of co-enforcement, saying, well, how do we introduce women's groups into workplaces as an additional actor that's going to come make sure that identity-based risks are taken into account, and taken into account in a way where we let the workers who are affected come forward and have voice and have agency. This is, again, this is the case with domestic violence, where women's shelters are doing a lot of training, working with unions, coming and presenting, have created tools that are then used within health and safety. Again, C190 is also an example where alliances between women's groups and unions have come together to make a really interesting combination and dynamic combination for prevention of violence and harassment at work. And this goes back to my initial remarks on the fact that we have to imagine sexual harassment in a new way, in a way that's much more holistic, and sometimes bringing in new actors, bringing in new interdisciplinary ways of interdisciplinary and intersectorial, as in the women who are affected's voice. Well, these kinds of reimagining of sexual harassment can be very dynamic and very powerful in the workplace. So I will end there. Lots more to say, but thank you very much for listening, and I look forward to your questions and comments.
Thank you very much, Professor Cox, for this very interesting and extremely rich presentation, and I think we really learned a lot. I hereby open the floor for questions. I saw two persons who raised their hands during the presentation, but they have perhaps changed their mind. I invite, if there is anyone from the audience, to raise your hands now or write your questions. Yes. Hello, Ken, please. Hello, Ken? Would you like to ask your question? I think we unmuted you. We don't hear you. Okay. We have. I think your microphone is off. don't hear him. Sorry? I think, Ken, your microphone is not working. While waiting for the next question, I would like to seize the occasion of me moderating this session to ask my question. I think what is very important as a point that you made in your presentation is the fact that what is appropriate for a specific context is really a context-specific actually exercise, what would be the best strategy. But what is interesting also as one of your recommendations as a member of the committee inquiring into law reform is the fact that you said that perhaps while this process of integrating psychosocial risks into the WHS framework is still ongoing, it is better probably not to integrate sexual harassment into that framework. If we go a little bit even further, because in some countries, violence and harassment is used as a term that includes also sexual harassment, would such a recommendation also hold true for violence and harassment in general? Because as we can see in some countries, for instance, the process of envisaging health, both in its mental, psychosocial, as well as physical, is still ongoing. At the same time, we have this pressing issue of violence and harassment in the world of work in general. So what would be your opinion or a comment on that?
And that's an excellent question. And as I said, I think that if we don't talk about sexual harassment as such, there always is a risk that it disappear and that this pervasive experience that women workers have. At the same time, the question is where, is it in the name of the policy? Is it in terms of an extensive risk assessment that is gender responsive? And so I think that there are a variety of answers to that question. I would certainly say that sexual harassment requires a specific risk assessment, whether it be, named as such or simply, 10 pages in the 20-page document. And I also, I didn't touch on very much on training, but I think that training on sexual harassment probably should be specific. Because it's particularly hard to speak about it. And, one of the reflections that we've had on training, when you look at the literature, is that what works are participatory approaches. What works are workers teaching each other. And in order to start that dialogue on sexual harassment, I think there's probably a variety of ways to ensure that sexual harassment is not invisibilized once again. So I don't think there's a prescription where we can say, oh, it has to be this way. I think it should be determined by the people in their own specific context with their own specific goals. However, I would say that there is a bottom line in that risk assessment for sexual harassment sure shares common factors, but they're also distinct ones. And I think that in each local setting, there will be specific areas for a risk of sexual harassment, and therefore that needs to be part of the policy. So naming, yes, somewhere. Where's the most strategic place to name sexual harassment? I think that might be context specific. Training on sexual harassment, again, I think we have to look at specific considerations about speaking up that will not necessarily be covered in general training on violence and harassment.
We have also another question from Alia Khan.
Hello, can you hear me? Yes, Professor Cox, thank you very much for a very comprehensive presentation. I'm connecting from Pakistan, and my question is, and it relates to ILO also, ILO's work on OSH, that primarily the OSH legislations are drafted on the basis of the now two fundamental conventions, ILO conventions. And C-190, which deals more with harassment, is still not a fundamental convention. However, what I'm trying to say is that still in terms of the legal inference from international obligations, C-190 is not grouped together with the OSH conventions, two of which are fundamental, and there are many others. So how do we go around this dilemma in terms of combining OSH with harassment at work? Thank you.
Yes, I mean, I would say in a Quebec context, looking at the international conventions, our approach was to say that the women's fundamental right to equality at work was a reason to implement legislation on work health and safety that deals with sexual harassment. So I think that the framework for the convention for C-190 talks about various types of legislation, be it labor law, human rights, occupational safety and health. So there are a variety, and at times criminal law. However, in its work health and safety dimension, I think that then we use that to connect to the conventions that do represent a fundamental right in conjunction with the equality rights protections. And in that sense, we can really frame the part of, we can frame prevention of sexual harassment in multiple dimensions as a fundamental right, in spite of the fact that C-190 as such doesn't benefit from the same status.
We have also questions on the question and answers chat. If I may just read one of them in the order that I received. Our colleague Zaina Mejer, I hope I pronounced the name correctly, she is asking the question, in local context where the definition of harassment is still vague and institutional response very weak, isn't it counterproductive to have separate approaches to sexual harassment and prevention of sexual exploitation and abuse? Perhaps to get employers, governments, workers, NGOs on board requires simple methods to such a complex issue. This affects reporting, investigation, support, etc.
Yes, I mean, just to be clear, I think that there's no, like I said, I don't think there's one right answer. So, but I think that, fundamentally, these kinds of debates have been played out before when we started saying, well, instead of talking about women's right to equality with sexual harassment, we're going to talk about dignity, because who can be against dignity? And so this kind of attempt to, I don't want to say water things down, but to present these issues in an innocuous way. For me, at some point, there is a moment at which you can't, there's no innocuous way of saying we're looking for fundamental change here. So there can be, I'm certainly not trying to say the strategy in this country should be X. At the same time, I think that we have to be mindful as we adopt specific pragmatic strategies to the fact that sooner or later we need to name sexual harassment. And I also think that sexual harassment is an issue that can be approached from a work health and safety framework. It can be approached from a women's equality rights framework. And so we have two different arguments to put forward. In Quebec, in Canada, in France, in Australia, the Me Too movements gave a lot of impetus for the work health and safety framework, because we all said, okay, we have to go beyond the individual prohibition. So in fact, sexual harassment has been a motor for other kinds of advances. If it can't work as a motor, if it's something that impedes progress, then I think obviously one has to be pragmatic. But as I said, at the same time, mindful of the fact that if we can't actually talk about sexual harassment, it's going to be ultimately quite difficult to prevent it. And that is part of the conversation, which is to say, let's start saying the name and let's start trying to help women recognize their experience as being related to something bigger. Are there different ways of doing that? Yes. Are there different moments of doing it? Yes. But I think ultimately, it seems to me that that's part of the goal, is to be able to start the conversation at some point. Don't know if that's a satisfactory answer. I don't think we're in disagreement, though, at all.
Thank you. I will continue reading the question and answers. There is another colleague, Stephanie, who is asking about the research about the existence of research on owner-led businesses where she is the harasser, and what are the recommendations for addressing such challenges. She then complements, I think, her question saying, it can be approached successfully as a safety and health issue where OSH legislation and workplace policies speak to safety, health, and well-being of workers. And then I think I will just finish because the chat box is complete. I think another attendee is asking about the issue of sexual harassment against men, or maybe it's just a statement.
Yes, so on the owner, when the owner of a company is the harasser, obviously, and is supposed to be processing the complaint, obviously that doesn't work. In the Ontario model, and also as a recommendation of the committee that I led, what we recommend is a specific provision where an inspector can order the employer to conduct a third-party investigation into a complaint. So that has been, in other words, if it's clear that there's no legitimacy to an internal complaints procedure, the regulator should be able to intervene and order a third party to conduct the investigation. And that's another important part of the WHS framework, is this capacity for the regulatory agency to give some oversight. And I think that's where the answer would lie, at least in terms of a policy in terms of small businesses. Certainly what we saw doing the empirical research were a number of, for example, of workers' compensation claims. It can be the owner, it can be in a family business that it's the uncle, the son, who's the harasser, and obviously the employer doesn't have a lot of credibility in looking into the situation or correcting it, and that's where you need external oversight. In terms of, yes, I've couched the issue in terms of sexual harassment of women. Can men be sexually harassed? Absolutely, often by other men. And it is an issue about, as my daughter would say, the she's, the theys, and the gays all go together on this one, in terms of the fact that sexual harassment is used to police masculinity as well. And so any man who is not, doesn't meet expectations can be the object of harassment. And definitely policies should go to and include, and the notion of sexual harassment includes sexual harassment of men. Absolutely. This said, when you do, that should be the opening statement, but when you do a risk assessment in terms of who is at risk and what kind of work are these people doing, your answer is going to come pretty quickly to the fact that we're looking at women workers at that point. But yes, a universal experience ultimately.
We have two more questions also in the chat. First, our colleague, apologies. We have two more questions in the chat. One is inquiring whether you had any recent articles that cover the issue in your presentation. And another one from colleague Nadia She's asking, is there any way to utilize ESG guidelines stemming from the EU to globally integrate guidelines pertaining to the prevention of sexual harassment in the private sector? Voila.
Yes, I can see the there should be a lot of people up here on the panel with me. So in terms of guidelines, again, yes, I think we need guidelines, and the guidelines have to be not only what to do, but also about how to do it to get the meaningful change. And that's why I started talking about how typically policies, procedures have been performative, have not been effective. So we really need to beware of this technocratic, on paper compliance. Here's the checklist, check the boxes, phew, it's over, that kind of, because, that doesn't work. So yes, we need guidelines, we need ways to do things, but then we also need to make sure that those translate to on the ground, meaningful exercises in specific workplaces. One of the examples that is emerging, I would say, is this notion of a safety walk, that actually physically walking through wherever it is that people work and talking about where the risks are there and soliciting the workers who know about the work that they do and who know about the risks, and saying to them, if you had a young woman doing your job, what advice would you give her? Where do you think she should be careful? What should be done? And that is often a way of starting to say, okay, people really know, if so-and-so's, everybody's angling for the good shift. They tend to be a little nicer to the guy who's making up the schedule, and here's what has happened in the past. So those things are known, So yes, general guidelines that say, here are things you could try. Again, I was talking about the fact that women don't spontaneously say, yes, there is sexual harassment here. So when you do, and definitely in a health and safety committee, that's not something that's going to come up spontaneously. So yes, there could be directives saying, well, we need an anonymous survey as well, or we think this tool would be appropriate for us so that people can disclose in relative safety about the risks that exist. And again, there are really a variety of tools that are starting to be used. One of them is, I'm trying to think, is this the right, escrow? Dépôt fiduciaire in French. So and that's a system where to deal with the risks of being known as the person who complained faced with a serial harasser. And again, harassers usually are serial harassers. So it's a system where workers can report an incident, often like online. And when a certain number of people have complained about one particular guy, it usually is a guy as an example, a notice goes out to everybody saying, you're now 6 of you that have, been targeted by this man. And that says to those women, first of all, I'm not alone. I'm not crazy. It's not me. I don't have to be ashamed of the fact I tried to be nice to him in the beginning. It's actually more than one person. And it creates a space, at least for some recognition, and hopefully also for somebody being able to disclose, knowing that she is not the only one, therefore that he can't trace the complaint specifically back to her. So, that's another, these are possibilities. Will they be appropriate in all workplaces? No. But should we begin cataloging them and putting them in framework directives? Yes. And as I said, I think the global unions are starting to do that kind of work. And the questions are, how can we study them? How can we figure out what is effective? And then next question, how do we get a trickle down to non-unionized workplaces on those questions?
Professor Cox, this is really great. Thank you so much for all the knowledge that you have transferred to us today. And I think what is also important is the way in today's presentation, we have really learned about the capacity of the work health and safety legislation in dealing with these complex issues, and also providing us such a granular approach to understanding, as colleagues said, extremely complex topic. And I think that with this, we will close the session. I thank everyone for coming today, as well as for participating. it has been a great pleasure for us once again. And thank you so much for accepting our invitation to come today to the ILO.
Well, thank you. And thank you everyone for listening. It's been a pleasure.